Good morning, Mr. Registrar. Could you call the case, please?
Good morning, Your Honors. Good morning to everyone in and around the courtroom. This is case number IT 0588T, the prosecutor versus Popović et al. Thank you.
Thank you. All the accused are present. For the record, prosecution is just Mr. McCloskey. Defense teams, I think everyone is here. Before we proceed, yesterday, because of Mr. Zivanovic, we didn't conclude or we didn't do the various housekeeping matters that we had planned. Let's do that before I give the floor to Mr. Stojic. Mr. Joss, when we first met again last week, you stood up and intimated that you had some kind of intention to make either an oral or a written application for a further statement from your client. And we had told you not now, and you had, if I understood you well, said that you will be proceeding to make an application. And you, of course, would like to know exactly where we stand with you on this issue.
I repeat, Your Honours, what I said the other day. I'm in a position to make that application at your convenience.
Yeah.
General Guerrero wishes to make a statement. It will be about 15 to 20 minutes in length. In terms of my application on his behalf, so that he be allowed to make such a statement, I'm again in your hands as to whether you want me to apply now.
And will the time be deducted from the 2.5 hours?
Well, that was something I was going to deal with in the course of my submission, because I thought that might be an issue. It won't surprise you to know that I'm going to ask that it not be deducted from counsel's time.
We just wanted to know, obviously. One moment. Yeah, okay. Yes, Mr. Begon, on the same issue?
Yes, same issue, Mr. President.
Yeah.
Good morning, judges. Mr. President, Drago Nikolic has informed us that he would also like to say a few words at the end of our submissions, whether it is today or whether it is completely at the end of the trial, up to the trial chamber. It will last no more than 5 minutes.
All right.
Thank you, Mr. President.
Okay, thank you. You know, Mr. McCloskey.
Yeah, I have no objection to any of these statements, especially given that and the time frame. I have no objection to that either.
Thank you. Anyone else of the accused wishes to volunteer a statement? None. Okay, thank you. Yes, Mr.
Could I just say, our preference would be for this statement to be given by our client
Before.
Well, in fact, after,
Okay.
at the end of all of counsel's submissions.
All right.
In particular, I was going to rely on some words of Judge Ori in the Krajnik case, where he said that occurs, quote, in the continental tradition. And that's at page 27449 of the Krajnik transcript.
Thank you. As if we didn't know. So, when you are in Rome, do as the Romans do. We are on the continent. Mr. Joss and Mr. Bourgon, your clients have our permission to address the trial chamber at the end of the respective presentations or closing arguments by you. Thank you. That's number one. One moment, because I lost. Yeah, and the time taken will not be deducted from your 2.5 hours. Now,
Sorry, Your Honours, could I just clarify this? The trial chamber would like our clients to make their statements at the end of our submissions, or at the end of all submissions. All submissions.
All submissions.
That was very much my preference. Thank you very much.
Thank you. And the same applies to you, Mr. Bourgon. That was what we meant, anyway. Now, Pandurovic defense team, following the testimony of Mr. Yevdovich, I hope he was not a protected witness, you tendered, and that was on the 17th of December, 3 documents which have not yet been formally admitted. These are 7D 1086, 1087, and 1090. We have an indication that the prosecution does not object, and the other co-accused also have not objected when this matter was raised in court. We need to decide it. If I have a confirmation from both prosecution and other co-defendants that there is no objection, then we will formally admit these documents. Yes, Mr. Haynes.
Yeah, I've been in correspondence, I think, with the court service and Mr. McCloskey about this. I thought they'd actually been admitted, but these are the calendars and things like that, aren't they?
Yeah, but they haven't been formally admitted as yet.
Okay. No.
No
Yes.
objection, Mr. President.
Okay, we hear no objection from the other defense team, so these 3 documents are admitted. Popović defense team. On the 1st of September, or thereabouts, I think it is the 1st of September, the Popović defense team filed 2 motions. One for approval of a revision of a translation, and the other one for authorization to remove 1 page from an exhibit. The time limit for the reply from anyone, prosecution and other defense team, is still running, but if you can put us in a picture now and tell us whether you have any objection to these 2 motions, you may facilitate matters and put us in a position to decide the 2 issues, motions now, orally.
Mr. President, I remember looking at that briefly. If I could get back to you before the end of the, well, certainly before the end of the hearing, and I'm sure I'll get a word via email in the next hour. I don't think it's a problem at all, but I would like to double check.
Thank you. And the other defense teams, no comments. Borovchin and defense team, on 4th September, you filed a motion to lift the confidential status of filings, of certain filings, and the decision related to the 10th August 2009 motion for disclosure of exculpatory information. Our understanding is that the prosecution does not object to this motion. That's the information we have been given. I would like to know if Mr. McCloskey confirms this, and if the other defense teams have any concerns or objections about this Borovchin motion.
No objection, Mr.
All right,
President.
thank you. We hear no objection from the other defense teams, so the motion is granted. On the 4th of September, the prosecution filed a motion to file a public redacted version of Chapter 14, that's the sentencing chapter, of its prosecution final trial brief. Are there any objections? I'm asking you if you could possibly respond now rather than wait for the time limit. Are there any objections from any of the defense teams to the prosecution request? No objections. So the motion is granted. Mr. McCloskey. Mr. Bourgon.
Thank you, Mr. President. On this topic, we would like to know what the position of the trial chamber is, whether the trial chamber will be requesting the parties to file public redacted versions of our respective final trial briefs, or if we just keep the confidential version which have been filed by all teams. Thank you, Mr. President.
I don't really, let me try see if I am reading you well. To my knowledge, most, if not all, of the defense final briefs were filed confidentially, but also publicly. At least I recall seeing some public versions. Yeah, some were in public version, definitely. They were all confidential in the first place. All right. Mr. Bourgon and the rest of you, our preference actually would be that whatever can be filed publicly is filed publicly, both on the prosecution and on the defense side, because it's in the public interest to know what the various positions are. I mean, it may take some time for each one of you to epurate and make the necessary reductions. But our preference would be if you can file your briefs publicly, those of you who haven't, then you are almost invited to do so. Okay? And
Thank you, Mr. President.
in the meantime, your decision, your motion is confirmed granted, Mr. McCloskey. And the same consideration applies to you. I don't know how easy it is because it's not that easy, but anyway, you can do it. There is the issue of some exhibits that are still MFI'd, and we are sorting those out. And there is the issue of some pending translations, and we may eventually end up with fixing a deadline for the filing of any pending translations. And you had stated, Mr. McCloskey, that you are working on the redaction of the confidential information of the intercepts with a view to being able to have them uploaded in the system by the end of the closing arguments. I would like to know exactly if you can update us on this.
Mr. President, I'm told that all the redactions are done, and it's now just the uploading into
All
the
right.
e-court process, which
Okay.
takes a while, but it'll definitely be done by the end of the week.
All right, we thank you all for your cooperation, and we can now move to Mr. Ostojic. You have nothing else to add, Mr. Jovanovic, have you?
Your Honor, I'd just like to apologize you because yesterday I overstepped my time allocated by the trial chamber.
Right. We,
Thank you.
as you and everyone else knows, we are very patient because at least I don't speak for myself only, I speak also on behalf of my colleagues. We all learned of the virtue of patience as being one of the most important things a judge ought to have. But on the other hand, we expect basic courtesy. I'm not attacking you, but we expect basic courtesy and also your colleagues ought to know whether they are going to start or whether today or whether they are going to start tomorrow. But so anyway, leave it. Thank you for your words, and we will now proceed with Mr. Ostojic.
Thank you.
Thank you. Mr. Ostojic, just give me 1 second. Okay.
Fair and thorough are two concepts that we expect in every trial. It is fundamentally the standard that must be strictly adhered to in such an extraordinary and significant case that is before this honorable trial chamber. My name is John Ostojic, and along with Mr. Predrag Nikolic and our defense team, we represent Ljubiša Beata. The OTP in this case, in his prefatory comments, has shared with the court that it's been a privilege to appear before you, and we certainly incorporate their comments. And without going into more detail, we certainly want to thank the entire staff, the translators, court reporters, as well as Ms. Stewart, who has assisted us with some documents throughout this case. It has been a long journey, and it is coming to an end for us. For the court, as you know, it is the beginning of the process of your deliberation. We viewed the evidence differently than the prosecution, and we hope during these closing remarks we can enlighten or share with you our precise view, which the prosecution has either ignored or simply failed to comprehend. We are not contentious because we want to be. We are contentious because we believe that they've used and adopted certain evidence and manipulated that evidence in order to fit a theory of one size fits all, a theory that they, in their initial statement in August of 2006, said that they do not believe in collective guilt. But when you truly look at their evidence, you will find that that is their theory, one size fits all, that every Serb who is in the VRS should be found guilty. We ask that this court look at the evidence as it will, and we're very confident that you will, clearly and dissect it as you would both the prosecution's case as well as the defense case. The OTP has remarkably weaved half-truths, uncorroborated and contradictory, inconsistent statements of biased witnesses with unreliable and tainted documents in a futile attempt to establish that Ljubiša Beata was purportedly involved in the crimes alleged in the indictment. In order to test the worthiness of the OTP's case, I respectfully submit that a practical and pragmatic approach is required and not a fanciful one-size-fits-all approach used by the prosecution. I do believe that the prosecution was not fair, and I do believe that the prosecution was not thorough in the presentation of their evidence. And what do we mean when we say not fair? I suggest to the court that they ignored evidence, although it is their duty, not ours, to present evidence to this trial chamber. They have the burden of proof. Which evidence, in short, did they ignore? Miloš Tomović, for example, the driver of Ljubiša Beata, an individual that they interviewed, an individual that we tried to get his statement introduced into evidence and were respectfully rejected. What other evidence did they ignore? We heard from Ms. Šoljan that there's no evidence of 1,500 to 3,000 Bosnian men from a column being killed through legitimate combat engagements, landmines, or suicides. How could they ignore the evidence of an independent source, such as Edward Joseph's report at Exhibit 1D374? Why do they ignore that evidence? How could they, after hearing that evidence and testimony, not address it or reconcile it? Further, on the issue of the column, they ignore completely not only the independent evidence of Mr. Joseph, but they ignored the evidence of their own investigator, Dusan Jans, who explained, I believe, during his cross-examination where the legitimate combat engagements occurred and what his estimates were as to the number of people that perished from those legitimate combat engagements. They give you a fanciful argument that there were some surface remains, and that's the extent that they'd like to share with us. So they ignore the independent evidence of a United Nations individual who was at the scene and on the site. They ignore their own investigator. But more importantly, they ignored the victims. The evidence that we introduced in connection with this case also were statements from people who were actually within the column. The Bosnian Muslim men who walked through Shushnari and made it through Tuzla or Kladan, they've given evidence in this case. And they've said at certain instances, we found that there were 500 dead bodies as a result of this combat engagement, 1,000 in another instance, 1,500 at another location. How could they ignore the evidence? Well, they do simply because it doesn't fit within their theory. Why do they ignore the evidence? Because they've persisted in a theory that simply is inaccurate, and in my view, they're trying to manipulate those facts. They talk about some and only a few of our defense witnesses, and we're still talking about ignoring evidence. They don't address Mr. Jaco Benefield. He was brought here to share with you the intent of Mr. Beata, how he is as a man, how he is as a person, how he is as a colleague, how he interacted with a different ethnic group. Mr. Benefield was clear and precise in what he said about Mr. Beata. They simply ignore it. Further, and perhaps most importantly, they ignore the evidence of 2D-PW-19, who was a Bosnian Muslim and brought here for the same reason, to share with the court what Mr. Beata's intent may be, how his relations were with other ethnic groups. Their position is quite simple. Ignore anything and everything that may assist an accused or may be helpful. Mr. McCloskey promised us certain things throughout this case, both in his opening statement and most recently in his closing argument. He said, I stick by my word. What I say in court is what I mean. He told us again last week that if there are two reasonable interpretations, that the court is required to accept the interpretation in favor of the defense. Yet throughout this case, when you view any piece of evidence, they never view it with the defense in mind. They have a narrow view of the evidence and have adapted it and adopt only their version. I strongly believe that the prosecution was not fair because they also distorted the evidence. Look simply at Exhibit 7D, 2D, 642. That is what we've called the Croat intercept, and I'm not still certain why it's given both the 7D and the 2D number, but that's what I've been told that it is, so it's 642. Look at the date of it, July 13th. Look at the timing of it, 11:25. The prosecution is the one, when I brought this evidence to them, that told me it was exculpatory. Now their position is, as reflected in their brief, that it's deliberately deceptive, that Mr. Berra was cunning in some of his actions. So that we understand their position, if there is any favorable or exculpatory evidence against the accused, all they can say is that they were cunning, they lied, or they were deliberately deceptive. Mr. Van de Puy, and I apologize for mentioning him because he's not in our presence, but I'm sure watching, challenged us on this exhibit. He tells the court in his closing remarks, the defense should have looked where the document came from. The defense should have found out the source. The defense should have determined who the speakers were in the conversation with respect to this document. With all due respect, that is not our job, and it is the job of the prosecution, who claims that they want the truth to be heard. They seized this evidence. They had the capacity and the manpower to answer all those questions for Mr. Van de Puy. We want that evidence to be heard. We want to know who was on that tape, and we want to know who the source was of those comments. You'll find it's interesting that the prosecution on one hand finds it exculpatory, but on another claims that it's deceptive, deliberately deceptive. As Mr. Van de Puy says, those two cannot coexist. You cannot have it both ways. When we talk about manipulation of the evidence, I was a bit surprised to see the prosecution relying on some witnesses. In fact, witnesses that they've called liars, and corroborating their evidence with other witnesses that they've called liars. That also cannot coexist. We've also seen, thank you, we've also seen the prosecution rely on evidence by an individual and then use self-corroboration to claim to the court that that's sufficient and carries the burden of proof beyond the reasonable doubt. For example, if I were a witness and I wrote down that I witnessed something or reflect upon it, can I use my own document as corroboration, or is that just one factor that you would utilize? The prosecution has no corroborating evidence in this case as it relates to Ljubiša Berra, and I will walk you through that evidence with time permitted. They tell you in a nutshell that they prefer quantity over quality. They claim that they have 14 witnesses that saw Mr. Berra from the 10th through the 16th of July, and that 10 of those witnesses purportedly saw him on the 13th and 14th of July 1995. I suggest to the court to look at the quality of those witnesses as opposed to the quantity of those witnesses. We will, with all due respect, go through, hopefully, each one of those rather briefly. The prosecution has from time to time argued that they have consistent evidence of certain facts, but that's not the standard. They must prove it conclusively beyond the reasonable doubt. When we speak of standards, I can't help but recall what Mr. Van de Puy said the other day with respect to Mr. Berra's witnesses. That's not the standard, Mr. Van de Puy. Mr. Van de Puy and the prosecution, in my view, have a double standard. Their standard is that if a young man comes in and testifies in court and makes a mistake as to when handball practice started, you should dismiss that testimony. The prosecution also believes that if a woman comes into court and she remembers details about someone's clothing, you should respectfully dismiss that testimony. What this court knows, and I apologize for having to remind you, is that the same standard should be used. And the hypocrisy in the prosecution is that they argue that witnesses like Milan Kerkez and Svetlana Gavrilović either did not have enough detail or were overly detailed and you should dismiss them. If they used their own standard and approached it against their own witnesses, none of them, absolutely none of them, would pass muster and would not be allowed to testify in this case. That's the hypocrisy in their evaluation of our evidence. They ignore evidence like Mr. Benefield and 2DW19, and yet they distort the evidence of other witnesses such as Milan Kerkez and Svetlana Gavrilović. I think they also manipulate the evidence with all due respect. They talk about a person by the name of Boško Momčilović, that he claims that he saw Ljubiša Beara on the 10th or 11th of July in the IKM in Pribičevac. Look at that evidence, as we will, and you will find that that is not accurate. It is not precise. It is not worthy of you giving any credence to it. It is, as Mr. Van de Puy said, quote, valueless, end quote. Likewise, I think the prosecution wasn't fair when they failed to keep their word. They told us from the beginning of the case all the way through the close of the prosecution case, when we gave our submissions, and they acknowledged that they called Mr. Beara an empty vessel, but they said, we have evidence that Mladic gave him orders. We can link it up. They don't. No such evidence exists with respect to contacts or orders or correspondence or reports between Mr. Beara and General Mladic. I've been advised, with the court's permission, if I can go into closed or private session for one moment.
Of course. Let's go into private session for a short while, please. Okay, we are in open session, Mr. McCloskey.
Thank you. It's actually, thank you. The prosecution also told us that Ljubiša Bata was an empty vessel, but that wasn't all he said last Friday. He also told us, as you remember in the opening statements, he used an idiom, and that is that Ljubiša Bata, quote, cannot hold a candle to Blagojevic, end quote, or any other commanders. They're required to explain what they said at that trial and to show you that they're taking a consistent view. They've not explained why they called Mr. Bata an empty vessel or why they used the idiom that he cannot hold a candle to any of the commanders. Thoroughness. I think the prosecution knows that during the cross-examination of various witnesses, we tried to show the court that they were not thorough or complete in some of their evaluation, whether it was their methodology, whether it was the materials they viewed, or the analysis that they provided. That completeness is necessary in all criminal proceedings, in my view, if the standard of proof is beyond a reasonable doubt. We tell the court they failed to call relevant, critical, and necessary evidence. It's perhaps naive to think that someone can make that charge and not be able to substantiate it. The prosecution, in my view, does it. The defense is restricted. But when I tell this honorable chamber that they failed to call relevant, critical, and necessary evidence, I'm referring to Nova Kasaba, July 14th, 1995. I am referring to Mr. Egberts. As everyone knows, the evidence purportedly that occurred that day was not, as it was with many of their 14 witnesses, one-on-one with Mr. Bata. Although in open, no one else observed them. This meeting with Mr. Egberts was between at least 4 individuals who were supposedly present, according to Mr. Egberts. Zoran Malinic was present. Why didn't the prosecution call him as a witness? Do they have doubt about what he may say? The prosecution listed Zoran Malinic in their 65 tur list. The prosecution knows that the 65 tur list is inconsistent with what is written in Mr. Malinic's interview statement. They have the obligation, if they want to corroborate the evidence and show the court beyond a reasonable doubt that Mr. Bata was purportedly present at Nova Kasaba, to at the very least call Zoran Malinic. Of course, they'll give you their same excuse. All Serbs are liars. You can't trust those people who were involved in this war. Why don't they call the interpreter, Nebojša, who was neutral? He was there. They had access to him, interviewed him, met with them. Their investigators clearly could have convinced them or asked or had him even subpoenaed to come here. But forget about Zoran Malinic and the interpreter Nebojša. They could have went 2 hours away from The Hague. And I think the town is Ansen, and I may mispronounce it. They could have got Egberts' former colleague in Dutchbad, Theo Lutke. They interviewed him. They had statements from him. It's their obligation to bring forth that evidence if they believe that they can prove that Mr. Bata was present beyond reasonable doubt. The fact that they did not bring such evidence forward, in my view, suggests that there is doubt as to his presence. Specifically, given the testimony of the various defense witnesses, there is little question but that there is doubt as to Mr. Bata's presence on that date. Finally, with respect to thoroughness and fairness, I'd like to say that the prosecution, not only in applying their standard with respect to defense witnesses, that they have a double standard, but they have a double standard as to even interpretation of words. By way of example, we can look at the Vasic documents. P60, P62, P886. Here's a person who acknowledges and admits his involvement in certain portions of the war. The dates of these documents are not only relevant, but are on point as to the entirety of the prosecution's case, the 12th and 13th of July. Here's a person who uses the word liquidation or killing in his July 13th report, P886, and yet the prosecution tells you with a straight face he really didn't mean killing. He was exaggerating the fact that Moop was solely involved to his bosses. He was exaggerating, he was killing, he was joking in an official document when he used the word killing. But in order to test the worthiness of their claim, we should look at the converse. Apply that to a defendant or an accused. If, for example, in the Croat intercept, instead of the word selekcija, selection was used, the person said liquidation. What would this court do to me as an officer of the court if I argued on the same principles that the prosecution does? He didn't mean it, he was joking, it's somehow distorted, or that he was probably trying to just sympathize or get some credit from his bosses. This honorable chamber would laugh us and laugh me out of this courtroom and out of The Hague. That's the double standard that the prosecution wishes to utilize, and that's the double standard that I think should not be allowed. If they want you to believe that Vasic was not involved, if they want you to believe that Vasic did not mean what he said, they simply have the recourse. He was here for a week waiting to testify. They withdrew him with very little in terms of an explanation. He's the one witness who may have, although I doubt it very seriously, corroborated some of the nonsensical evidence that we've seen with respect to Mr. Deronic and whether there was a meeting with Mr. Beara or not in Bratunac, in the SDS offices. They don't call that evidence because that evidence doesn't support their case. They don't call people like Malinic and the interpreter and Theo Lutke because there is doubt and flaws in what Mr. Egbert said with respect to Beara's presence. The prosecution, in its closing remarks, proudly regurgitated its brief and highlighted that there were 14 witnesses. As expected, and as I've stated, they've chosen quantity over quality. Let it be, since I'm moving to the issue of specific witnesses, I want to say this to the court and to the prosecution. Let there be no doubt that I would prefer one Milan Kerkez over 100 of their Momir Nikoliches. Let there be no doubt I would prefer Svetlana Gavrilović and Mira Cekic, over hundreds of Deroniches and Nikoliches and Vasiches and PW 161, or for that matter, anyone from Bratunac. The first witness that the prosecution uses in their brief to highlight or claim that Ljubiša Beara was involved in any of the actions relating to Srebrenica and Žepa appears on paragraph 2187, and then on paragraphs 2203, 2204, and 2205. In order to be fair and thorough, we must dissect the evidence of each witness and then determine whether that witness should be considered credible and worthy. The OTP relies on one witness and only one witness to claim that Ljubiša Beara was at the IKM in Pribičevac. This single witness and his faulty recollection was not confirmed by any other witness. It was not confirmed by any other documents or any other intercepts or even the infamous Zvornik Brigade duty officer logbook. Others have testified in this courtroom regarding the IKM in Pribičevac. Others have testified who was present with Krstić at the IKM Pribičevac. Prosecution witnesses testified in that regard. If they believed Boško Momčilović, they could have gotten corroborating evidence from other people who were present when Mr. Momčilović claims he saw Mr. Beara. There is no corroboration from either other witnesses who were present, such as PW162, such as Mr. Deronić, such as defense witness Milenko Jevđević. There's no record of any source to substantiate or corroborate this claim. This witness stands alone with respect to this date, but this witness, like 9 others on their list of 14, is not alone when you look at the common denominator that there is no corroboration for his evidence, there's no support for it either in the documents, the intercepts, or anywhere else. Look at Butler and what he says with respect to Mr. Beara's whereabouts. It's the prosecution's military analyst. Certainly, he wouldn't have lied with respect to whether or not Beara was present at the IKM Pribičevac if there was any reasonable source of information to suggest that Beara was present there. He was not, and therefore the court should not consider this evidence standing alone without corroboration to support the fact or claim that the prosecution is offering. If that isn't enough, look at the unrebutted testimony of the defense witness who said, and that's Ljuban Mrković, we had his intercept. It's reflected on the July 10th that he states that Ljubiša Beara was at the Sarajevo-Romania Corps for 4 or 5 days, and that Ljubiša Beara afterwards told him that he was going to the Krajina region. On the 10th, he's saying this on the intercept. When he testified, it was unrebutted. Božo Momčilović's uncorroborated, unsubstantiated, and erroneous recollection cannot be given any weight whatsoever. No records, no video, no documents, and no other witness support his claim. If the court recalls, there was one other witness that gave testimony, and that was a person by the name of Dragoslav Trišić. Dragoslav Trišić, I think, told the court uniquely what the problem is with these recollections. Initially, he claimed, surprisingly, to both the prosecution and the defense, in an interview, not in court, that he thought he may have seen Mr. Beara at Potocari. Simply not true. Prosecution knew it, never argues it, doesn't argue it because they know it's not true. During his testimony, he explained that he did in a prior interview mention him because he felt pressured. He felt pressured to just name everyone and anyone that he knew. He knew that Mr. Beata was indicted, so he just threw him in a vacuum of people that may or may not have been present. With all due respect, there is no credible evidence whatsoever that Mr. Beata was either in Potocari. There's no evidence of that. And there's certainly no credible evidence that Mr. Beata was at the IKM in Pribicevac. Momcilovic also, I think if you look closely at his testimony, as opposed to lumping him in the 14 that purportedly saw him, he lied under oath. He said that in 95, 96, I saw Mr. Beata on television in order to substantiate his claim. Mr. Beata was not on television. That was verified by the prosecution themselves when they cross-examined Professor Wagner. Finally, with respect to Mr. Momcilovic, who was he? What kind of a witness was he? He was a character witness for Momir Nikolic, someone that the prosecution themselves suggest has not only provided half-truths and lies, but it's someone who came into this courtroom during his sentencing and provided character witness testimony for Momir Nikolic. Enough said on the first witness. The next group of witnesses the prosecution wants to claim, because they want to enhance their case and say that Beata was in Bratunac from the 10th through the 12th of July, 1995. They identify 4 witnesses: Zlatan Celanovic, PW 161, respectfully Mr. Borovchanin, and I gotta get this right again, PW 138. When you view this evidence, they utilize and rely on these witnesses for other aspects of their case, not just the 10th through the 12th. But when you view these individuals as we're about to, I think the court will find that they are not credible and not worthy of being given any weight to their testimony. With respect to Zlatan Celanovic, the first and most, and perhaps the impressive issue with him is that the prosecution acknowledged and puts forth immediately that Zlatan Celanovic is terrible with dates, cannot remember or recall specifically the date of any meeting or anything that happened. Transcript at page 6627, the prosecution asked the following question, quote, "And I want to go to the time of about the fall of the Srebrenica enclave. Now, I know you've testified before that you weren't real good with dates. Is that right?" "That's correct." End quote. Zlatan Celanovic, if you view his testimony carefully, clearly did not see Ljubiša Beata from the 10th through the 12th, at least until the evening, as he later claimed, of July 1995 in Bratunac. He admits he's not good with dates. He's vague when he met Beata. How could you get it wrong, whether you met someone in the morning or in the evening? I could certainly understand someone saying it was mid-afternoon or early evening or late afternoon. How do you get it so diametrically different from, I think it was either the evening of the 12th or the morning of the 13th? This meeting, like many meetings with purportedly Mr. Beata, were mano a mano. Never was there a third party, with the exception of Egberts. These people have these secret meetings in the middle of town, in offices that don't belong to the military, in places where secretaries see people coming in and out, and there's supposedly military policemen at the door, unknown people sitting in the conference room who happen to be colonels and lieutenant colonels, never identified. But yet the only person that comes and testifies is one individual who claims to have seen Beata. There's no record to support this claimed meeting with Zlatan Celanovic. There's no other human being who testified that they saw Zlatan Celanovic with Mr. Beata. How could there be a record of the meeting between Zlatan Celanovic and Mr. Beata? We can draw from our own personal experiences. And if, as the prosecution claims, that Mr. Beata gave an order to Zlatan Celanovic that he needs to interrogate and he needs to investigate, and Mr. Celanovic does interrogate and investigate certain individuals, you would expect to find in some of his records or in some of his paperwork that he was instructed or ordered or asked or requested by Ljubisha Beata to do any of these things. The prosecution is relatively angry and upset because if we accept the proposition that Zlatan Celanovic is credible, although he stands alone with no documents supporting his version, Butler acknowledges there was nothing illegal or improper with respect to the request made at that time on the evening of July 12, 1995, to interrogate, to investigate. They believe Zlatan Celanovic when he claims that he saw Ljubisha Beata on the 12th in the evening in Bratunac, all alone. But they do not believe him as to the perfectly legal discussion that Celanovic claims he had. In that regard, Mr. Van de Puy and the prosecution say Mr. Beata was cunning. He was cunning. Where's the proof of that? Isn't that manipulation? Isn't that distortion? What is the basis of making a claim like that? None. If this honorable trial chamber accepts Zlatan Celanovic's testimony, the only time he would have been able to see Ljubisha Beata was on the 12th of July, 1995 in the evening. And you respectfully must accept at face value what Celanovic claims Beata purportedly said to him. You cannot accept the prosecution's baseless version that this was a cunning man trying to deliberately deceive everyone with respect to the work that was purportedly at hand. Celanovic indeed says that the interrogation process proceeded and that Beata said these individuals would be transported to Kladan. Celanovic also confirms that he spoke to another individual, a bus driver, who also told him that the individuals would be transported to Kladan. I refer the court to the transcript at pages 6631 through 6632 and also at 6641. The second witness that the prosecution relies on to try to prove or establish that Ljubisha Beata was present in Bratunac is an accused, Mr. Ljubomir Borovchanin. And with the highest of respect to Mr. Borovchanin, I don't have a case against him, and I'm not trying to prove a case against him. Last Friday, but when you view this evidence, the court allowed it in. I need not remind you what the rules of evidence are and what weight you should give evidence that we, Mr. Beata's defense team, did not have an opportunity to closely scrutinize and cross-examine. But look at what the prosecution told you on the 4th of September 2009 with respect to that interview statement. With all due respect to Mr. Borovchanin, the prosecution said, look, quote, look at his false statement, end quote. He is lying to me, end quote. There are radical changes from the statement to what's in the brief, end quote. Wait, let me get this straight. The prosecution wants to use Mr. Borovchanin's statement against us, but yet they're telling this court that he lied, that it's a false statement, that there's radical changes to it? Those concepts, respectfully to Mr. Van der Pue, do not coexist. PW 138, which is a third witness that the prosecution uses to support their claim of the 14. In his testimony, the OTP is relying to establish Beata's presence again in Bratunac from the 10th through the 12th of July 1995. But let's take a refreshingly honest and closer look at what he actually said. If we examine transcript page 3802 through 3803, we'll find the following passage, quote, question by the prosecution, quote, so let's take Colonel Beata, for example. Can you tell us whether you know whether he was in the area of Bratunac before the fall of the enclave, end quote. Answer by PW 138, quote, I've just told you that I really cannot say whether he, they're referring to Beata in parentheses I'd place, was there before the fall of the enclave or not. Further, PW 138 says at transcript page 3803, line 16, quote, it's all mixed up in my mind, end quote. I'm not sure whether I saw Mr. Beata. It's all mixed up in my mind. The prosecution abandons this witness as to a charge of reburial with Mr. Beata, and yet they now want to tell this court that you should rely on his testimony. We further test this witness's credibility by virtue of the fact that no one has been brought in to corroborate his claim. No records exist, and no intercepts were ever disclosed which would remotely support such a claim. It does speak volumes to the prosecution that they abandoned PW 138. It does speak volumes as to how they view his recollection, his testimony, as well as his credibility. Relying on a witness such as PW 138, who cannot recall anything with specificity, and admits that he is mixed up, and acknowledges he is uncertain, would be, as Mr. Van der Pue shared with us, quote, valueless, end quote. The next witness, PW 161, perhaps, but I think certainly, one of the least credible witnesses that this court has been asked to evaluate. It's clear that with respect to PW 161, that he is inconsistent with his interviews, his prior interviews with investigator Ruiz. And you can find that quickly and briefly, both in our brief, but also I'll provide the site, which is 9419 and 9420 page number. This witness was called as a defense witness in the Blagojevich case in order to support a ridiculous claim of parallel chain of command. This witness was brought in the Blagojevich case to support that Mr. Blagojevich was not present or not at Bratunac and did not give orders. This witness, however, when asked whether he can share with us how many times he met with the Blagojevich defense, couldn't remember. Not sure. This witness and his selective memory should be rejected by the trial chamber. He acknowledged at that time that he indeed gave 4 or 5 different versions. This witness also claimed that he did not see Momir Nikolic at that time in Bratunac. If Momir Nikolic is right, and he sees Mr. Beata in the center of town, and from my understanding, there's only one road that leads to that center of town on any given day, how could this witness with any credibility stand before this court and tell you he never saw Momir Nikolic? He also, this witness, PW161, claims he didn't see Ljubislav Simic. Here's an individual who worked and coordinated in 1992 with Deronic, was involved and connected with the killings and the murders that occurred in Glogova, in the Bratunac area in 1992. He now comes into this courtroom and tells us that he did not see any of the principal perpetrators of the crimes that occurred in Bratunac in 1992 or 1995. Look carefully at PW161's testimony. He had a meeting at the restaurant Yasan. He claims with Mr. Borovchanin, but also with Miroslav Deronic. He tells us it was soon after the Kravica killings. Here's what PW161 said when asked if he remembered anything about that meeting and about the incident that occurred at Kravica as the question was posed to him. The question referenced incident at Kravica. He says at transcript page 9364, specifically lines 20 through 21, quote, "It was discussed that evening, but I truly don't remember what Miroslav said, what Borovchanin said, what I said. We talked a lot." This witness that the prosecution is relying on, who said that he doesn't remember what was discussed after a horrific massacre, after killings were completed at Kravica, he has the audacity to come into court and tell us he doesn't remember what was discussed? This witness, who was in charge by virtue of his capacity and employment with digging and obtaining machines, both in 1992 as well as in 1995, realized how deep he was with respect to his criminal culpability and his criminal responsibility. He had no way out. He had to claim that someone else ordered him to do the digging at Glogova. Again, with most, if not all, of the prosecution's 14 witnesses, this witness is not corroborated by any other witness. He also sees Beata mysteriously alone. He does say there were 2 other VRS officers in the room, one a colonel, one a lieutenant colonel. He claims Beata was in the room. He tells you, conveniently, that he doesn't remember the other 2 individuals' names. He tells you that when he came into the SDS offices, Deronic was not there. He passes the secretary, as we know her name now is Mirna Nikolic. He doesn't check in with her. She doesn't make a record of it. There's no evidence to support his claim. He stands alone with respect to his claim that he saw Beata that evening. He does not stand alone with respect to the evidence the prosecution is bringing against Beata. He, as others, like Zlatan Celanovic, like Egberts, like Božo Momčilović, all have this unique quality. They all see Mr. Beata alone in the middle of town with many people passing, with thousands of people in buses. They're the only ones who see them? No support whatsoever. No MOOP records? No records from the civilian authorities that PW 161 reports to simply state, I was asked, I was requested, I was ordered, I had a meeting with this individual. No evidence of that at all. Further, when you evaluate PW 161 in his testimony, you have to view the evidence of one other individual, Momir Nikolic. Momir Nikolic either had a reawakening or he came to his senses to tell in part the truth as it relates to this plan, to this lie, to shift the responsibility of the killings in Kravica and the burial at Glogovo to Mr. Beata. Momir Nikolic, in his testimony on page 33128, acknowledged to the prosecution that PW 161 lied about the alleged Beata involvement in Glogovo. I asked Mr. McCloskey and Mr. Van de Puy in particular, although Mr. Nichols, with all due respect, is the one who interviewed him and obtained that information initially for us, why didn't you follow up with PW 161? Here's a lead. Here's a witness that you had on your list, a witness you entered into a plea agreement, a witness who now is saying something different than the witness that you brought forth into court. Are we not owed that obligation? Is it not their duty to be fair and thorough? Is it not their duty to bring forth at least some truth in this courtroom as it may relate to an accused? PW 161 was involved with the 1992 Glogova killing and burial. PW 161 was similarly involved, at least in the burial in Glogovo relating to the Kravica warehouse killings. PW 161 had a tight-knit group of individuals whom he could trust and perpetrate and perpetuate a false claim, a claim that he thinks will somehow absolve him of responsibility. His evidence was not only contradicted by Momir Nikolic, his evidence was inconsistent with other statements he himself had given. His evidence was not corroborated by anyone or anything. This is the witness that can be coined as deliberately deceptive or cunning, but certainly not Mr. Beata. Moving along, the next group of witnesses that the prosecution offered in this case relates to the evening of the 13th and 14th of July 1995. There are 4 witnesses that they utilized to support their claim, 2 of which we've already touched upon. That would be Mr. Borovchanin as well as PW 161. Who is left? 2 individuals who have pled guilty, 2 individuals who acknowledge and admit that they were involved in war crimes in former Yugoslavia. 1 individual, Miroslav Deronic, who acknowledged his involvement in the crimes against the Bosnian Muslims in Bratunac and Glogova in 1992, and Momir Nikolic, who I think still, although it was unclear from some of his testimony, was involved in the tragedy that occurred to the Srebrenica enclave and the people that made their way through Bratunac and through Zvornik. Those are the four individuals that they rely on. Mr. Van der Puy was quite clever in mocking or trying to mock the defense and saying, was someone walking around carrying a suit or a mask of Mr. Beata? No. That's not our defense. Our defense is when you dissect the evidence fairly and thoroughly, you will find that the evidence the prosecution stands on has no foundation and should not be accepted and given no weight. The cunningness and deliberate deception does intertwine with Momir Nikolic and Miroslav Deronic. However, they couldn't even get their story straight. Although they are in-laws, related, their testimony between themselves was inconsistent, contradictory, unsubstantiated by others, was not confirmed by records, intercepts, or other data. Mr. Nikolic, the self-admitted liar, he told us he lied about critical issues. He told us he had previously lied about his involvement in Sandici, as well as his involvement in the Kravica warehouse. The prosecution is really relying on that evidence. He admits that he lied along with PW 161 when they tried to include, shift, and blame Mr. Beata for the killings and burial relating to Kravica and Glogova. He admitted it. We do not, and we respectfully ask you not to accept Mr. Nikolic's false, contrived evidence and suggest that you reject the same. Deronic's story does not coincide with Mr. Nikolic's. It can't, because a lie will ultimately be unraveled. Deronic's story about the alleged meeting in the SDS offices with Beata Mr. Deronic passed away during the start of this trial. We did not have an opportunity to cross-examine him. That evidence, much to our disappointment, was nonetheless introduced. There was no evidence to substantiate or corroborate from a credible source Mr. Deronic's view or recollection of the events as they may have occurred, specifically relating to Mr. Beata. What the prosecution could have done was at the very least bring forth Mr. Vasic, as I've previously stated, if they wanted to, if they truly believed anything that Mr. Deronic had said. Mr. Deronic, just like Mr. Momir Nikolic, is a self-admitted liar. We've highlighted for you, and we've taken an enormous amount of time in our brief showing you how other people viewed Mr. Deronic's testimony and recollection. But in order to highlight some of those, we can take a closer look and review Mr. Deronic's statements and credibility. In my view, can best be described as follows. The forensic value of his statements and testimonies is extremely limited. Not one of the trial chambers which heard from Deronic were satisfied that he was credible or reliable. For example, the appeals chamber in Krstić, while analyzing Deronic's testimony, cautioned to everyone, because they knew and had the wisdom that the prosecution may use Mr. Deronic's testimony in other cases. They cautioned and said, we, quote, hesitate to base any decision on Mr. Deronic's testimony without having corroborating evidence, end quote. I see that it may be close to the time I'm not sure if I'd be allowed just to maybe finish with Mr. Deronic or if the court is pressed for time.
Not at all. Please go ahead.
Thank you. A closer review of any evidence offered by Deronic reveals that his statements are not only not fully correct, it is difficult to number the times Deronic admitted that his previous statements were deliberately not true. The court has also found in other instances that the details of his statement cannot be taken as true, that he gave false testimony, that he was not truthful in prior instances. Deronic's testimony should be rejected in its entirety. I have a question for the prosecution. I wrote these things in our trial brief. Why didn't they reconcile it with the court? Why do they stand there proud as a peacock to tell us we have 14 witnesses that claim that Beata was there from the 10th through the 16th? Let's dissect it. Their obligation, and it is mine, when they ignore my evidence, to tell them they've ignored it. They could have, and they should have, told the court how they truly view Mr. Deronic's testimony, despite the fact that we didn't have an opportunity to cross-examine him. The only thing that Deronic may have said that was remotely true was when he claimed on P3139, that's the exhibit number, page 119-120. When he was interviewed with the prosecution and talked to them, he told them, in giving now my second or third interview, I've prepared better. Of course, he doesn't mention, as uniquely, no other witnesses mentioned Mr. Beata until well after the Krstic case. But this witness in particular says to the prosecution that he's consulted or he's used some friendly connections, end quote, to recreate the chronology of the events. Unsurprisingly, those connections and those people he consulted were the people that he met with in order to perpetuate his lie as to who was ultimately responsible. We're grateful for the intercept that shows Deronic discussing with former President Karadzic what should be done with the POWs. Does that not indicate Deronic's involvement? Does the fact that he was appointed to the position that he was clearly reveal that he was responsible for those POWs? Look at the timing of that intercept. At 1000 hours, July 13th, and it's exhibit P1149. It's immediately prior to this, or not immediately, it's prior to this purported meeting with Mr. Beata. No mention by Karadzic that he will send him a secret source to inform him what to do with the POWs. No mention in that intercept or any data that Karadzic will send a messenger or a courier or an individual to tell Mr. Deronic what to do with the POWs. Karadzic, through an interpreter, simply tells him what to do. Place them in the warehouse. You know what to do. Deronic's testimony in this regard, if you look at what he said on the 8th and 9th of July when he met with Karadzic, that he was already instructed by Karadzic to kill the Muslims. He was already instructed by Karadzic to apply the Western Slavonia method. How do you reconcile now his purported claim that Mr. Beata comes to his office at midnight or at 1 in the morning? Simply put, he made it up. He lied in order to shift the responsibility that he had, to shift his involvement from the crimes that were committed and were about to be committed to someone else. How do we explain, and I'm shocked that I didn't hear it from the prosecution, how do they not reconcile that Deronic doesn't want the individuals in Bratunac, but purportedly Beata comes in and sees them and says, I want to move the individuals. And they get into this mysterious, heated debate and discussion? Why would it be heated? Dernich supposedly wants them out. Beata allegedly is asking to move them. There should be no debate. The point is that their lie was uncovered in part. The point is that their lie cannot hold muster. The point is that there is no evidence to corroborate or substantiate by any other individual that Mr. Beata was present on either the 13th or 14th of July. It might be, and I appreciate the additional time past the hour, I do have a couple more comments on Mr. Dernich, but I think it's a good place to stop, if I may.
Thank you. We'll have a 25-minute break now.
All rise. Forgive